Linda Evangelista is a supermodel. We knew her from the 1980s and 90s,
I remember
right?
her specifically from the Freedom 90 video of George Michael.
Yeah?
She was in that lip syncing to it. Yep, that's
just
how I remember her.
She was everywhere. She was one of those big names. But she wrote this on Instagram last week. Today I took a big step toward righting a wrong that I've suffered and have kept to myself for 5 years. To my followers who have wondered why I have not been working while my peers' careers have been thriving, the reason is that I was brutally disfigured by Zeltek's cool sculpting procedure, which did the opposite of what it promised. It increased, not decreased, my fat cells and left me permanently deformed even after undergoing 2 painful, unsuccessful corrective surgeries. I've been left, as the media has described, unrecognizable. I've developed paradoxal adiposity hyperplasia, or PAH, a risk of which I was not made aware of before I had the procedure. PAH has not only destroyed my livelihood, it sent me into a deep cycle of depression, profound sadness, and the lowest depths of self-loathing. In the process, I've become a recluse. With this lawsuit, I'm moving forward to rid myself of shame and going public with my story. I'm so tired of living this way. I'd like to walk out my door with my head held up high, despite not looking like myself any longer. So I wanted to get with Mark Cantor, Cantor Injury Law, personal injury attorney extraordinaire here in the St. Louis area. Mark, how are you? Haven't talked to you in a while. Good to have you back.
I'm great. Thank you for having me on.
So in this case, it seems like maybe she does have a case. What's your assessment here?
Well, she wouldn't have a case in Missouri.
Okay.
Missouri has a statute of limitations for medical malpractice of 2 years, and Missouri has a cap on non-economic damages. Those are damages not related to work. So, the pain and the suffering and things like that everyone's afraid of in malpractice claims is actually capped in Missouri right now at $442,574 for non-economic damages. And
I'm guessing a guy like you doesn't really like that very much.
Well, sometimes it's appropriate and other times it's not.
Yeah.
There's a difference between catastrophic injuries and non-catastrophic. I'm labeling this one as a non-catastrophic injury. It was an elective procedure that she chose to have. And at Cantor Injury Law, we would not accept this case because she's proceeding based on this PAH, which, you described, and that's an informed consent issue. So, this is the classic case of the hairy hand. It's the first thing that you learned in both contract and tort law in law school. And you may have watched, or your viewers may have watched, listeners, the paper chase. They started Harvard Law with. So the hairy hand case was a guy that burnt his hand, and this surgeon came in and said, hey, I'm going to make your hand look normal. So he takes a piece of flesh from his chest, and he puts it on the guy's hand. Well, now the guy's hand is hairy. And so, it's a little bit of a mixture.
Yeah, I've never heard this, but I never went to law school either, so that's interesting.
Yeah, so it's contract, right, because you were promised to have a good, normal hand. And it's tort, it's malpractice because, they messed it up. So what is this? What is this cool sculpting? She was promised one thing, and she alleges that she got another. Is it a contract case or is it a malpractice case? And then in the hairy hand case, the court in New Hampshire ruled that it's your expectation. What did you expect to get, and what did you end up getting? So I would have to, I don't know Linda, and I haven't seen her. I certainly would like to see her and see what the damages are. I don't know whether.
Is there any protection for Zeltek in? I'm certainly, like with any other medication, you have side effects, potential side effects. She says that some of those weren't disclosed, but wouldn't they have some protection over side effects because there's always, the possibility of something like that happening?
Well, so what she's complaining about is called informed consent. That the doctors didn't tell her that this could happen, and it does happen on rare occasions. So, there's both a potential products liability case as well as a medical malpractice case. And so, you have to explain to your patients all the things that could happen. Again, at Cantor Injury Law, if it's just informed consent, we won't take the case. It's got to be something else that went wrong. So, I don't know the specifics, and again, I haven't seen her alleged damages, but it's not a case that we would routinely handle at my law firm because I tell my young lawyers if it's just informed consent, that's more like a contract than a medical malpractice case.
I find it interesting, Mark, and I guess I knew this just from covering stories over the years, that you'd have different states having different laws regarding lawsuits like this. But are they, in some cases, it sounds like they might be dramatic differences.
Oh, for sure. Yeah, I mean, some states don't have caps on damages. Missouri has caps on damages. And what you said earlier, that you probably don't like them. I don't like them because I've seen tremendous injuries to people that don't deserve it from medical negligence. And those people, that's why we have a jury in Missouri, so that they can determine damages. If you get a multi-million-dollar damage for pain and suffering right now in Missouri, unless it's a person that's a quadriplegic or a paraplegic or lost 2 limbs or has a permanent cognitive brain loss, according to 538.205 of the Missouri Revised Statutes, the most you can get is $442,574.
That seems low to me. I'm just going to say that does seem a little low.
It's unfairly low, and it goes up 1.7% per year. And so people are, and we've politicized lawsuits in this country. And so, a lot of people hate lawyers because of them, and until they have a serious injury, and then they're calling us, and then we're their best friends. I try never to take a frivolous case. I'm not commenting on Linda's case, whether it's frivolous or not, because, again, I haven't seen her damages. She was a beautiful supermodel, and she says she was brutally disfigured. But, those people also age out.
Yeah, well,
so I don't know.
There is that, right. Yeah,
right. So I don't know. I don't want to comment because I haven't seen what she's claiming to be brutal disfigurement. But it's an interesting set of facts because it could be a contract case, could be a medical malpractice case, could be a products liability case. So there's a lot of different ways to analyze this fact pattern. And with my professor hat on, I can as a businessman and a lawyer. Obviously she's claiming a lot of damages and she's a superstar, but in my firm, if a person called in with this set of facts, we're unlikely to accept it.
I feel like I've already passed the LSAT just by knowing about the hairy hand case. So I appreciate Professor Cantor. Mark Cantor with Cantor Injury Law. I appreciate you coming on with that insight this afternoon. Good to talk with you, Mark.
All right. Thank you very much.